Each section has its own approach. So I broke this down by each section and gave you an approach for each section. What I'm going to do right now is go through the approach and just kind of highlight what's tested as a way to kind of cut down on some of your studying. So I'm starting here on page 3 with types of concurrent estates. Joint tenancy is tested in trusts, it's tested in wills, it's tested in community property, it's tested in real property. You need to know what a joint tenancy is. You need to know that it's a tenancy created with time, title, interest, and possession, and it needs to be in writing and expressly created. I'm on page 4. You need to know how to sever. You need to know, first of all, that a joint tenancy has the right of survivorship. So you own property in joint tenancy, and if you die, the property automatically goes to the other joint tenant. It doesn't go through probate. It doesn't go through any of that. Joint tenancy is really a good thing if you don't want to be dealing with ownership of property, and maybe you're married or not married to somebody. Owning something I always advise gay and lesbian clients to own property in joint tenancy so they don't have an issue with family coming in and not honoring the relationship and having problems in a probate court. So joint tenancy is a great way to own property. You have a right of survivorship. You can sever a joint tenancy by an action for partition, and the severance of people become tenants in common. Okay. A testamentary disposition cannot change or sever a joint tenancy. You cannot own property in joint tenancy and then will it to somebody else. So if me and Bob Gould own a house in joint tenancy, he cannot put in his will that the house goes to his daughter. The house, when he passes away, goes to me. If I pass away first, it goes to him. Okay, there's tenancy for the entirety, which is a marital ownership of property. Look at the right of survivorship, look at how it's terminated. And these are terms you just have to kind of be familiar with. The one you need to memorize is joint tenancy, because that is tested. Tenancy in common, each tenant in common owns an undivided 1/2 interest in the property. There's a right of partition, possession, rents, and profits among tenants in common as co-tenants. Okay. Under landlord-tenant, now the bar loves landlord-tenant, and the last bar had landlord-tenant. Under landlord-tenant, the first thing you look for is what type of tenancy has been created, what kind of leasehold. I'm on number 8. Is it a tenancy for years? Is it periodic? Is it at sufferance where you're a holdover? Now, the important thing with all these tenancies is how are they created and how are they terminated. Creation and termination is an issue for each of these. One of the things you may need to look at on a lease agreement is whether it crosses over in contracts. Sometimes they do a contracts crossover in real property on a lease. Okay? And look to see if there's a statute of frauds problem. Okay? And look to see if there's any implied or express covenants. The most important thing on page 11 is landlord's duties and tenant's remedies. Landlord's duty implied in every lease is the covenant of possession, covenant of quiet enjoyment. If your covenant of quiet enjoyment has been interfered with, there can either be an actual eviction or a partial eviction or a constructive eviction on the top of 12. Covenant of habitability is tested all the time. And what are the tenant's remedies? I'm on 12. The landlord also has a duty covenant to make repairs. On the top of 13, we now have the tenant's duties and the landlord's remedies. The tenant has the duty to pay rent. The tenant has a duty for destruction of premises. Landlord's remedies for tenant's failure to pay rent is on 14. If the tenant fails to pay rent, the landlord can evict or sue for the rent. What happens if the tenant abandons without justification? The landlord can do nothing or repossess. The tenant's duty to repair. The tenant has a duty not to allow permissive waste. In other words, the tenant does not have a duty to make substantial repairs, but the tenant does have a duty to tell the landlord if the sink is leaking and could cause flooding or mold. Okay? And they can't cause affirmative waste. or cumulative waste. The last bar had assignments and subleases. Could give you a contracts crossover again. In assignments, there's a question about whether there's a covenant against assignment or subleasing and whether that covenant runs with the land. And under assignment, the landlord can sue the original tenant. Under a sublease, the landlord cannot sue the original sublessee. So in assignment, the assignee substitutes for you, and under assignment, you still have responsibility. Under a sublease, the sublessee comes in and takes your position. Fixtures, for some reason the bar likes fixtures. They always give you gas stations with tanks in the ground, and then a ballet studio comes in. Fixtures is not really difficult, but they test it a lot. Fixtures means that it has to be something permanently affixed to realty. Okay? Is that chattel can be removed as long as it does not substantially injure the property, and removal takes place within accepted time limits. I'm on conveyancing on 19. Now, I'm not going through the mini approach, but I've given you a mini approach before each section. This is kind of your cut sheet. On conveyancing, is there a valid land sale contract? Another place they can give you a contracts remedies crossover. Who has assumed the risk of loss? Has the seller delivered marketable title? But the one they really test is the validity of the deed. For some reason, they love this one. This is tested bar after bar if property's tested. And the main thing on that is the delivery of the deed. There's a general presumption that a grantee in possession of the deed, there's a presumption of valid delivery. If the grantor is in possession of the deed, there's a rebuttable presumption. If the deed is recorded, delivery is presumed. Now, the one they test is delivery of the deeds to third parties. No delivery if the grantor retains control. Delivery on death of the grantor. No delivery if the conditions are within the control of the grantor. That, because delivery really means that you have an express manifestation of intent to divest yourself of the property. You've taken an action to divest yourself of it. You've transferred it to somebody. It's a problem if you retain control. Delivery on an uncertain condition beyond the control of the grantee. Like I'll give you like in tonight's question. He gets the deed upon the guy's death. Okay. Let me say this. If you don't have valid delivery or a valid conveyance, look to see whether the person gets the property by adverse possession. That's how they test this, always. There's a problem with delivery, and the question is, did the person get the property not by conveyance, but by adverse possession? Adverse possession, super heavily tested. Adverse possession, you need, okay, so check for adverse possession. There are 3 forms of deeds on the bottom of 21, not too heavily tested. Recording on 22 is heavily tested. On the recording acts, there's 3 types of recording acts. The thing you're going to look for in recording is whether the person is a bona fide purchaser. A bona fide purchaser is a purchaser. They can't be getting a gift from you. They can't be an heir. They can't be a donee. They have to purchase. Did they take without notice actual constructive or inquiry and for valuable consideration? If you are a BFP, you're a purchaser, you took without notice of someone else's rights, and you paid valuable consideration, you may be protected. There are 3 types of recording statutes, and these are heavily tested. The first is notice, and there are 3 types of notice, and these 3 types of notice are tested in 5 subjects. In other words, notice can be tested in wills, it can be tested in other subjects. Notice is either actual notice, where you actually know. The subsequent purchaser must show that they did not actually know of any prior unrecorded conveyance. Constructive notice, which is record notice, which is recorded notice, that even though you didn't know there was a deed recorded with the county office. And inquiry notice is that you were put on you're put on notice to inquire further whether there's another subsequent purchaser is bound to make reasonable inquiry. and you're bound by any facts that a reasonable person would know. And then you have race notice statutes and race statutes, and these you need to know for the MB also. Now, if we don't get it by conveyancing or recording, we get it by possibly adverse possession. Adverse possession requires that it be, okay, if it's ineffective for any reason, I'm on the top of 25. You don't have a valid deed, there's something screwed up in the conveyancing. Adverse possession requires that your possession of the land be open and notorious, actual and exclusive, continuous for the statutory period, and hostile. Hostile meaning against the interest of the true owner. The problem with tonight's question is the guy took it under claim or of title. How can it be hostile when he thinks he owns it? And it also has to be for the statutory period. Okay, now we're moving on to page 28. Easements. Easements are non-possessory interests in land. You don't own it. It's a right to use. For example, on Leonard's property, if the only way to get to the main road is through his neighbor's property, that he doesn't own that land that goes through the main road to the neighbor's property, he gets a chance to use it if he has a proper easement. There are different types of easement. You need to know the differences. There's affirmative easement, a negative easement, easement appurtenant. You need to know how an easement's created. Is it expressly created on 29? Is it by implication? Is it by reservation? Is it by necessity? Let's say that the only way to get out to the main road is to use the neighbor's property. He gets an easement by necessity. He can't be bound just to stay on his own property and can't get out. Or an easement by prescription. Easement by prescription is that you use the walkway between the two properties for 10 years or more and everybody's been using it. You get an easement because of the statutory period. What is the scope of the easement? How is an easement terminated? A license is not an interest in land. If you have a license that's revocable at will, that's considered, usually a license is revocable at will, unless you have a irrevocable license, which is a license coupled with an interest. A profit is where you're able to remove something, oil, minerals from the land. You don't own it. You don't have a right to use it. You have a right to remove valuable objects from it. The next issue that is very heavily tested is covenants running with the land. Non-possessory interest. Only run the burden, everybody. Only run the burden. If the burden runs, the benefit will run. If the burden runs, the benefit will run. You don't need to run the burden and the benefit. Requirements for the burden: there has to be an intent to bind successors in interest. The successor in interest has to have notice. Horizontal privity means that there has to be some relationship between the original parties outside of a covenant, a leasehold, some other relationship. And vertical privity is you stand in the same line of interest as the person that's above you. You take their interest. Horizontal is this way, and vertical is that you step in the shoes of the successor in interest. And does it touch and concern the land? Does it affect the land? Okay, the important part about covenants is there are questions where they'll ask you, is this a covenant or is this a servitude? Covenants allow you to get damages. On a remedies crossover, covenants allow you to sue for damages. On an equitable servitude, you can only sue for equitable relief, injunction, etc. So the benefit, you have to look at what the parties want. If they're looking for money, it's for covenant. If they're looking to stop the neighbors from building this as a commercial area when it was originally residential. So for an equitable servitude, how do you create it? Implied equitable servitude is created from a common scheme, plan, or design. On 34, you need notice. It needs to be a common scheme. Enforcement of the equitable servitude. You're basically enforcing the burden running. The thing that's nice about equitable servitude is you don't need privity. You just need intent, notice, and it has to touch and concern the land. Now, Security interest in land. I'm over here on, hold on a second, on 36. Security interest in land. You need to know the difference between a mortgage, a trust, and an installment land contract. And you need to know how to transfer mortgage to the mortgagee, and about foreclosures. And they ask this usually maybe on one call on about every third bar. And installment land contracts. Yeah. A lot. I couldn't agree. I agree completely. The essays test it maybe every fourth essay, but Mitch is completely right. I had a student call me after the last bar saying, you know, Sherry, I thought 10 of the 30 property questions were mortgages and liens. I mean, so you really need this for the MBE. Thank you. This is a big MBE subject. Take MBE questions. Make sure you do your flashcards. Make sure you know how to do these. I don't know why they're so big on the MBE, but I imagine the most modern real property issues are mortgages and liens issues, especially this MBE is in 36 states. And a lot of you have foreclosures and mortgages, and I mean, they have changed it. Thank you. Okay. Now, rights incident to ownership. These are lateral support, subjacent ground, and water rights. I mean, they haven't tested this in 3 bazillion years. Maybe, Mitch, would you agree, 1 MBE maybe? Or more than 1? Maybe 1. Don't blow it off, but at the most. This is not heavy on the MBE subject. Now, land use control is zoning. Zoning crosses over in con law. Okay? You can get a real property con law crossover with zoning and contracts. Now, the thing about zoning is there's an issue, the constitutional issue is when they zone and say to Leonard that this land cannot be used for commercial purposes, it's only for residential purposes, and if you want to have 15 horses, you can't do it. The question then becomes, is this a taking without due process of law? Okay? Are you taking land from me? You're telling me how I can and can't use it. This constitutes taking. Okay? Zoning mechanisms, there's also spot zoning, where they give somebody a chance to have a kennel, but nobody else in the neighborhood can have it. And there's also, what do you do about non-conforming uses? Non-conforming uses is a use that's in existence at the time, and then they zone it after that. And usually on the non-conforming uses, they grandfather those in. That's why he's getting to do what he's doing. Okay? And the consideration constitutionally on 41 is due process, equal protection, and is this a taking? And I promise you I'll cover this in con law when we get there. Now, I'm going to say something about future interests. If you love future interests, knock yourself out. I think it's about 3 MBE questions, maybe 4, and the people that love it still miss 2 or 3 of them. Okay, if I were you, I would, I had my limits on what I could deal with on the bar exam, and future interests and fertile octogenarians and all of that just was past what I really personally could cope with. That's just me. I'm telling you personally. When I got there, I said, okay, I'm willing to dance with these bar examiners. I am willing to do everything I can. But I friggin' don't know what a fertile octogenarian is. I don't get how somebody 80 years old is considered a fertile octogenarian. I know it made sense in King Henry's time. God bless them all. I'm not studying this stuff. Now, I'm not telling you what to study and what not to study. This is not a top priority. If you love it, knock yourself out. Now, I would know what a fee simple is. I would know what a remainder is. I would know what a life estate is, because they'll tell you that the mother deeded the property to the son to live there the rest of his life, and when the son dies, it goes to. Those are the basics. What a remainder is, what a fee simple is, what a life estate is. But if you're trying to figure out rule against perpetuities and all of that, you know, you're probably a lot smarter than me. Because there was a professor at Pepperdine that I was talking to one day, and I said, can you just sit down and talk to me about the rule against perpetuities? And he did explain it. And he did a great job. I can't, it just flew out of my brain after I understood it. It's just like gone. So I don't know, maybe it's this thing about whatever. I know some people do like it. Couple MBEs, not on the essays, if time, and if you're bored, need to sleep, don't want to take some kind of sleep medication, read this. I know, and you know what? They are almost giving, because there's people like me saying, forget about it. You know what I mean? Like, you're going to spend 3 days trying to figure out rule against perpetuities when you could be doing 10 other things that make more sense? Mortgages and liens. Put your time into mortgages and liens. Okay, I agree. Yes. All right, now, I want to go through tonight's question. You've been excellent, outstanding. You don't look too dead tired. It's a good thing, huh? Which one is that? Yes. We're going to pass it out while we go through it so that you're not blown off your socks and just completely sleep. No. Okay, we're going to go through this question. Now, the call of the question asks you about the rights and liabilities of Arthur, Bart, and Charles. Arthur, Bart, and Charles, you have 3 columns. I would start by saying Arthur's rights to Blackacre depend upon whether he obtained title to the property as a result of a valid conveyance or by adverse possession. Okay, my first head note's conveyancing. I go through validity of the deed, and I go through the problem with delivery. The problem with delivery here is he said, I want you to use this property. It's really going to be yours. Here's the key. Here's the box. When I die, open it, and you'll get the deed. But what happens is the key doesn't open the box. So the question is whether he intended to deliver it and deliver it to whether Owen intended to give it to Arthur or whether Owen intended to give it to Bart. Okay? We're going to look at delivery. We're going to find there's a presumption of valid delivery. We're going to deal with the fact that the wrong key is a rebuttable presumption, that we presume delivery, but the wrong key rebuts that presumption. And we're going to presume, I'm going to presume that delivery did go to Arthur. Now, the next issue is, the problem is, Owen is the life tenant. Owen comes in and does what? He cuts down the trees. The question is whether the life tenant created a waste. And the issue is, if the deed was void for lack of delivery, Owen didn't commit a waste because he still owned the property. If the delivery was valid, then Arthur owned the property, and cutting the trees was an affirmative waste. The next argument is, if we don't have the conveyancing as valid, did Arthur have adverse possession and obtain title by adverse possession? And adverse possession requires that it be open and notorious, which it was, that it be actual and exclusive, which it was, that it be continuous, which it was. But the problem is, was it hostile? He's possessing the land under claim of title. Claim of title does not satisfy that it's hostile against the ownership of the true owner. So he probably is not going to get this property by adverse possession. So you're going to say Arthur may get the property by valid delivery. If Arthur gets the property by valid delivery, then Bart does not get it. If Arthur gets the property by adverse possession, Bart doesn't get it. If the delivery's no good and the adverse possession's no good, then Bart gets it under the will or the testamentary disposition. If Arthur has acquired title, B has no interest in the property. The next issue is the rights of Charles, and it's going to depend on the recording statute. This statute, under these facts, is a notice statute. Here, A's deed was not recorded, so C had no actual notice. Constructive notice, again, there's no recording. He didn't have that. Inquiry notice, they tell you that he built, this was a big piece of property, and where was the dwelling? In the middle. So did he have inquiry notice? I think probably not. And thus, if it is likely that C had no notice of A's interest in Blackacre, and as such, the statute's protected. Thus, the lien on Blackacre stays and A is subject to the lien. Alternately, if C is charged with inquiry notice, then the lien against Blackacre is void. That's this question in a nutshell. Now, pretty fast nutshell. Let me give you the assignment for the next class. You do have an exam on Saturday. The exam questions subject are civil procedure, professional responsibility, real property, and community property. Lucked out. We waited on real property because we knew these would be too many subjects, too tight. You know, so you have, and then after next week, things lighten for you a little bit. You have a couple of classes off, I know. So let me give you the assignment for the next class. The next class is Trusts and Wills, and the in-class assignment is question 17, Childless. Trust and Wills question 17. Trust and Wills question 18, Fran and Sis. So question 17, Childless and Trust and Wills. Question 18, Fran and Sis. For your study group, in Trust and Wills, question 8, Bonnie. Question 14, Ted and Fred. And question 12, Fabulon.